The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court, now sitting.
Good afternoon and welcome to this session of the Kansas Supreme Court. I would ask Mr. Doug Shima to please call the docket.
Thank you, Your Honor. The 1:30 p.m. docket for Wednesday, September 13th, 2023 consists of one case, appeal number 125621 in the matter of Tereshawn D.D. Morton, original action and attorney discipline. We are ready to proceed, Your Honor.
Thank you, Mr. Shima. Counsel, would you please state your appearances and for the record?
May it please the court, Gail Larkin, disciplinary administrator, appearing on behalf of the Office of the Disciplinary Administrator, present and ready for argument.
May it please the court, Tereshawn Morton, I appear pro se.
All right, thank you. Ms. Larkin, you may proceed.
Thank you. This is an original action and discipline filed by the Disciplinary Administrator's Office against Ms. Morton. The respondent was admitted to the practice of law in Kansas on July 8, 2016. On June 16, 2022, the Disciplinary Administrator's Office filed a formal complaint against the respondent, alleging violations of the Kansas Rules of Professional Conduct. While the respondent filed motions, objections, and affirmative defenses, she did not timely file an answer to the formal complaint. After the Disciplinary Administrator's Office filed a supplement to the formal complaint, the respondent filed that same day, the respondent filed an answer to both the formal complaint and the supplement to the formal complaint. In her answer, she admitted some facts, denied others, but denied violating the 3 rules of professional conduct as outlined in the formal complaint. On August 23rd, 2022, a hearing panel of the Kansas Board for Discipline of Attorneys held a hearing on the formal complaint. The hearing was conducted by Zoom. Because counsel to the Kansas Board for Discipline of Attorneys had a conflict, a former board member, Nick Badgerow, served in that role. He also appeared by Zoom. At the conclusion of the hearing, on behalf of the Disciplinary Administrator's Office, I recommended that the respondent's misconduct warranted disbarment. On September 20th, 2022, the hearing panel entered an amended final hearing report memorializing its findings of facts, conclusions of law, and recommendation for discipline. The hearing panel concluded that the respondent violated the 3 rules outlined in the formal complaint, KRPC 7.1, communications concerning a lawyer's services, KRPC 8.1, bar admission and disciplinary matters, and KRPC 8.4, professional misconduct. The hearing panel recommended that the the respondent's license to practice law be indefinitely suspended. The respondent took exceptions to the amended final hearing report and the parties briefed the issues. Turning now to the facts which gave rise to the formal complaint. This case arose from issues regarding the respondent's website, her Kansas bar application, as well as several Colorado bar applications. In November 2020, Kansas attorney Brandon Davies of Roth Davies discovered that the respondent had copied significant portions of content from his firm's website and pasted that content onto her website. As a result of the respondent's actions, when the term Roth Davies was searched in an internet search, the respondent's website appeared in the results. In addition to a reference to the Roth Davies name and telephone number, that also appeared on the respondent's website. In November 2020, Mr. Davies sent the respondent a letter by certified mail, as well as an email message asking her to remove the Roth Davies content from her website. The respondent did not respond to Mr. Davies' communications. A week later, he again demanded that the respondent remove that duplicated content by email message. Again, she did not respond to his communication. The email messages that were sent to the respondent's correct email address. During the disciplinary proceedings, the respondent asserted that she did not receive any of the communications sent by Mr. Davies. The respondent's website included many pages of the Roth Davies website, including legal analysis and case summaries developed by Roth Davies. The respondent's use of the Roth Davies website made it appear that the content was the product of her labor and experience. On her website, she also identified herself as an experienced attorney practicing in the areas of criminal defense, personal injury, and workers' compensation. Contrary to her assertion that she was an experienced attorney, she had limited experience practicing law. She had been licensed for only 4 years. For at least a portion of 2016, she was employed full-time as either a school teacher or a school principal. And her practice during that time was limited to the evenings and weekends. In 2020, the respondent described her practice at that time as relatively small legal practice. In her February 2021 response to the complaint, she stated that in November of 2020, she had no criminal cases, and at that time had previously only handled one criminal case. In that same response, she stated that she had not taken any new cases in any practice area until the close of 2020. In addition to describing herself as experienced on her website, she also indicated that she copied and pasted the logos of bar associations when she was not in fact a member of those associations at that time. She copied and pasted the Martindale-Hubbell AV rating logo on her website, and she had not been rated as an AV lawyer through the Martindale-Hubbell service. In fact, she wasn't eligible for that because she had only been practicing for a few years. On January 11, 2021, Mr. Davies filed a complaint against the respondent with the disciplinary administrator's office. After receiving the disciplinary complaint, the respondent disabled her website. While Mr. Davies' complaint remained pending, our office learned that the respondent had a pending bar application in Colorado. We also learned that she had failed to disclose the Kansas bar complaint to the Colorado admissions authorities. As a result, Tom Stratton, then Director of Investigations for our office, conducted additional investigation. Mr. Stratton discovered that by July 2021, the respondent had reactivated her website. On the reactivated website, she continued to identify herself as an experienced attorney practicing in the areas of criminal defense, sex crimes, and personal injury. On the July 2021 version of her website, the respondent listed practice areas to include motorcycle accidents and wrongful death cases. The respondent has not handled any motorcycle accident cases or wrongful death cases. Again, the respondent copied and pasted her bar associations or the bar association logos when she was not in fact a member of any of the associations. During the follow-up investigation conducted by Mr. Stratton.
Counsel,
Yes,
can I ask you, those allegations largely support, I mean, maybe a little bit of all the violations, but the false or misleading communication about lawyer or the lawyer's services, is there a mens rea, or what is the intent requirement to support a violation of 7.1, or if there is one?
I don't think that there's any language in the rule which tips its hat as far as what the mens rea is. I do think there's sufficient evidence in this case, though, to establish that the respondent engaged in knowing conduct involved in the 7.1 violation. Specifically, knowledge can be inferred from the circumstances, as this court has said many times. She had complete control over her website. She didn't hire anybody else to draft her website or post anything on her website. She had complete control over that. She knew what was on there. She had actual knowledge that she was not a member of the associations or had not received the award from Martindale-Hubbell. She knew she was not an experienced attorney. I think I've outlined the different pieces of that information that establish her lack of experience, specifically with those practice areas where she had never handled any cases or had handled only one case. During the hearing on the formal complaint, she talked about her experience and how she based a lot of her experience on the fact that she worked as an intern for the public defender's office while in law school. She took down her website in 2021, but put it back up in July 21 with some of the same offending material. And finally, she knew that she had cut and pasted information from Mr. Davies' website without doing the research and writing herself. So she was aware of all of those things. I do believe that the one kind of element that cast doubt on her knowledge was her belief that it was not a live website, her belief that it was somehow hidden from the public. That's something that's, I think that's one of those things that you could certainly take judicial notice of the fact when someone can Google something and find it on the internet. She should be charged with knowing what is out there, knowing what she's posted, and knowing the effect of that post. When Mr. Stratton conducted additional investigation, he compared the 2019 Colorado bar application with the Kansas bar application, and many differences were discovered. First of all, the employment history varied from application to application, and most significantly, on the Kansas bar application, she omitted her employment with the Boys and Girls Club, while she did disclose that on the Colorado bar applications. That's relevant and material because she was fired from that position for engaging in fraud and for theft from that organization. Specifically, the fraud and the theft kind of took two different types. On one occasion, in December of 2007, she requested a check payable to the Sam's Club in the amount of $3,000. She took that check to the Sam's Club, purchased some items for her own personal use, and applied that check toward those items and applied the balance to the Boys and Girls Club account. The value of the items that she purchased for herself totaled about $400. In addition, while she was employed as a regular employee of the Boys and Girls Club, she basically paid herself twice. She had a salary and she also paid herself hourly. The value of the double payment exceeded $4,000. To date, she's not paid back the Boys and Girls Club either the $400 from items purchased at Sam's Club, nor the $4,000, which she obtained by fraud through payroll.
I jump you to the 8.4 findings of the panel.
You bet.
It's both subsection C and subsection G. The findings, I think, are the same for both 8.4 violations. And it appeared from the briefing that both parties agree that 8.4 would not apply to any conduct that predated the respondent's licensure in Kansas. Is that a fair summary of your position?
Certainly.
Okay. And that excludes a lot of the findings I think the panel relied on. Failing to disclose a lot of information on her Colorado application, or failing to disclose on the Kansas application, her employment with Boys and Girls Club, and all of those issues that you just discussed, for example. And it looks to me like maybe we're left with just a few findings to support the violation, including the information that was on the website, the 2019 Colorado bar application that she said she voluntarily resigned from Boys and Girls Club and an investigation revealed no wrongdoing. And she failed to disclose to the Colorado bar that an ethics complaint had been filed against her, the complaint in this action. I'm not seeing any other findings that would have, occurred while she was licensed in Kansas.
I do think
Am I missing anything?
I agree. The findings would be limited to the 2019 Colorado bar application and the website, the false statements on the website. And I certainly talk about the different things that were on the website in the Colorado 2019 application if you'd like, but those are definitely the categories of the dishonest conduct that remains. With regard to KRPC 8.4C, in relation to her website, she engaged in conduct involving dishonesty in 4 different ways. First, she copied that content from the Roth Davies website and pasted it onto her website. That was the legal analysis and case summaries that Roth Davies had developed. She included that Martindale Hubble AV rating on her website. She included the Bar Association logos. And she asserted that she was an experienced attorney when she lacked experience. Sometimes she had either little or no experience in each of the practice areas she identified. And then as it relates to her 2019 Colorado bar application, she engaged in conduct involving dishonesty in 3 ways. First, she included false information about her termination from the Boys and Girls Club. She failed to update her application to disclose the disciplinary complaint in Kansas. Both Colorado and Kansas have an ongoing duty to report or to update the bar application. And once the bar complaint was filed in Kansas, she had a duty to notify Colorado of that. They did not know about that through her disclosure because she did not disclose that. It was only when they asked for information regarding her current status in Kansas that they came to know that there was a pending complaint. And finally, she failed to update her application as she obtained new employment. In fact, during the hearing on this case, she was provided providing additional information about employment that had not been disclosed up until that point.
Is there any reason to, do we know whether that was material or not? In terms of 8.4, her employment with, was it El Pueblo Boys and Girls Ranch?
I don't know that the El Pueblo Boys and Girls Ranch failure to disclose was material or not. I certainly don't know of any fraud in that employment, but there were subsequent positions that she held that I did not learn about until the actual hearing on the complaint in this case. And so I don't know if there was any issues with those employments or not. But there was the 2019 Colorado bar application was pending for a period of time, and then during that time she changed jobs and did not update Colorado. So whether it's material or not, I don't know, because we didn't investigate that because it came at the time of the hearing. I see that my time has run out. I will stand for any additional questions, or otherwise I will complete my argument through my rebuttal time.
What is your recommendation for discipline today?
My recommendation for discipline today remains the same as it did at the time of the hearing, and that is I recommend that this court disbar the respondent. Had our office learned about the termination from the Boys and Girls Club during the admissions process, I would have recommended to the Board of Law Examiners that she not be admitted. Whether the Board of Law Examiners would have, how they would have viewed that misconduct, I don't know, but I know that how we would have viewed it. Because she engaged in disconduct in that, or dishonest conduct in the employment, as well as dishonest conduct subsequently, our position is that disbarment is warranted.
Are there any other questions? Thank you, Ms. Larkin. Ms.
I believe
Morton.
that Justice Rosen might have a.
Oh, I'm sorry, I missed it.
I'm sorry, I was muted and I didn't realize that. I'm a little confused, Ms. Larkin. You said you're not using conduct prior to the bar application, but you just referenced conduct prior to the bar application with her employment with the Boys and Girls Club. Can you clarify that for me? Because
Certainly.
she didn't include it in the bar application. You wouldn't have recommended she sit for the bar, but how are you not then bootstrapping that conduct in?
I'm not basing the 8.4 C and G violations on conduct that occurred prior to her admission, but certainly 8.1 takes into account the bar admissions process. And because she wasn't honest in the bar admissions process, the conduct at the Boys and Girls Club is relevant today, and it does constitute a violation of 8.4 C. Not the actual misconduct itself, but her failure to disclose that employment, which would have led to the discovery of that misconduct at the time of the bar admissions case.
I just want to make sure I understand that when you are saying that you would, upon learning about the reasons that she left the Boys and Girls Club, you would have immediately recommended that she not be admitted to practice. That's not what you normally do. What you normally do is you would refer it to a panel, right? I mean, it's a character and fitness issue, correct?
I certainly jumped a couple of steps in the process.
Yes.
But when an application comes in, we would have investigated it. And assuming that the investigation and the character and fitness investigation revealed what the disciplinary investigation revealed, our position would have been this matter needs to go to a hearing. That recommendation would go to the review committee, which consists of 3 lawyers. They would review it and decide whether or not a hearing would be held. And then if they decided a hearing would be held, I would have at the time, because I was the admissions attorney at the time, I would have presented that case to the Board of Law Examiners, and then they would have made a decision about whether or not Ms. Morton would have been admitted.
Thank you.
Any other questions? Okay, thank you, Ms. Larkin. Ms. Morton.
Thank you. Please forgive me up first. In the response brief, for the first time, the statements Best Overland Park domestic battery lawyer and Best Overland Park, Kansas criminal defense lawyer appear for the first time. Those statements appear on pages that I've always testified were not intended to be published. I have always taken responsibility for not knowing that unpublished pages could not be discovered online. The 70 pages that were meant for publishing make no such reference. I'm completely aware and took responsibility at the outset that Mr. Roth Davies and other information not discovered appeared on my unpublished pages. When I found out about it, that it was discoverable through his website manager, I immediately took the entire site down trying to figure out why that was an issue and removed all such pages. Mr. Davies did send me a letter, but in the record is that that letter is returned to him unsent. And I'm not sure during the COVID process and online why I didn't see the emails. But surely if I had intended to plagiarize his information and had gotten alerted by it, I would have removed it. And this may not be before the panel. This entire thing may not be before the panel as we sit. The missing positions, as Justice Wall pointed out, including my new positions, have not been shown to be material. A reminder that during COVID, I started working in a document review position, and I have admitted that I was not successfully managing my application, COVID, and my practice. And so for that reason, I withdrew my request to practice in Colorado, got alerted to this matter, and dealt with this exclusively and wound my practice down. The pages that were referenced to motorcycle accidents and wrongful death never any way, in shape or form, referenced my experience in them. In fact, they're just informational pages. And although I disagreed about the use of the term experienced, because I'm not inexperienced, I just have limited experience. And although those pages were informational pages only, I removed those. I think it's important to note the order in which I got alerted to issues. The first complaint, the initial complaint told me about the Martindale Hubble. I do have an active profile with them. I just chose the wrong logo. I do have 4 out of 4 stars, which is what reads on that logo, and I didn't know that AV was different. When they told me about it, I removed it. Also, when they told me about the Roth Davies information, I removed it. After the secondary complaint and then receipt of the formal complaint, I learned of the issues with my saying that I was experienced and the logos. Those were, I admit, were my negligence, and I also removed those and took my website down for a second time. When I produced my website for the third time, I alerted the administrator and the panel. And as we sit here today, never again have any of those things or any new things been at issue. I'm down to maybe 6 or 7 pages on my website now instead of the 70 I had, but that's okay because I want to avoid any issues in the future.
So
Mrs. Wall, someone became muted again.
I'm out of practice with being online, sorry. So the timeline on the website publication, initially there was some distinction between published and unpublished. Can you first help me understand that just from a technical standpoint? Because I don't know exactly what that means, but.
Yes, I have a website that I do, like Ms. Larkin mentioned, manage myself, and it allows you to create template pages, hidden pages, and then pages that you actually click published on, which you expect for the internet to see. And I produced a copy of that was a function of my website during the panel hearing. Those pages you can use just as you're dumping information or as you're drafting new pages to produce. So when I published my website, I found out through this process that in fact those by like web crawlers or I guess just general Google can still be shown if the rights terms are included. So for instance, Roth Davies was included. He didn't discover all of the pages that I had that were not just his information, from which I admitted to in my initial answer that included like Wikipedia, CLEs, and et cetera. So those all sat on those pages, but his website manager was looking for Roth Davies. And so I appeared in the source results, which is how I discovered, and he discovered that was an issue. So now, sorry.
Oh, sorry. So then you go through, you redact certain information and then repost it. And then the second sort of reposting, the disciplinary administrator says it still had, objectionable material on that. And what I was hearing you say but that the material that was objectionable was not previously identified to you as part of the scope of the investigation.
Right, as part of the scope of the initial investigation. And so then the second one came out and the formal complaint. And then I was alerted to using the term experience in my logos. And I lost the benefit of all of those associations the moment those expired. Those were not taken from me. There was no misconduct found. I used them really as backlinks so that my Google search engine would go up. The minute I don't appear in those expired. So if they had clicked any one of those, I lost all the benefit. However, I have taken a CLE that talks specifically about why the general public relies upon associations of that sort, although they are really for the benefit of the lawyer. And I recognize now what a big deal that was. And that I was wrong. So I've always taken responsibility for that. I wasn't trying to defraud anyone. It just was my error.
And then the third posting, which is completely cleansed, was that submitted to in part of the record and before the disciplinary administrator?
I testified
before the hearing panel. I'm sorry.
I testified to that, and I also alerted them that the third time it was posted that I had reposted it, and no other complaints were brought forward, which they did do. Ms. Larkin did file one supplemental complaint, and I imagine she would have if there were new pages I issued. May I continue?
Yes.
Thank you. I've objected to the subject matter jurisdiction related to my Colorado bar application. My argument against that is plainly and within the cases that Ms. Larkin the administrator relies upon. In her brief, just as in her brief, the frequently referenced cases on the topic include opinions of Crandall, Dennis, Walsh, Estep, and the Estep courts. At issue in those was whether or not Kansas could regulate attorneys who were practicing law, licensed in Kansas, were practicing law outside of the state. There's no issue here about whether or not I practice law outside of state. Rather, this involves my application to the practice of law in Colorado. And this court respectfully has no judicial or police power over my Colorado bar application. And although the administrator wishes this court, to accept Malone, Regent, and Thomas Bellamy on page 19, paragraph 1 of the brief in support of authority to impose discipline on an attorney for statements made on a bar application in another state, each undeniably misses that mark. In each, the respondents were found to have committed misconduct only after they were given the opportunity to defend the allegations in the controlling jurisdiction. Next, the statements made were determined to be materially false, which we have, this court has already discussed, most of them are not. And only then do the outside states consider to take steps to impose reciprocal jurisdiction. Tom Stratton actually conducted a supplementary investigation, which the administrator has referenced, and he learned of my OVL listing related to my Colorado federal practice at the time. He contacted Colorado's Office Attorney of Administration and talked to Don McKnight. Ms. McKnight shared that I was not licensed in the state court. And as I argued in my opening brief, she then exceeded her authority and shared my pending bar applications, which was not substantially similar to the Kansas matters, and Kansas had no authority to otherwise review. As a result, the number of Colorado bar issues were absorbed by Kansas. And I would again argue that Kansas's gain of information there was wrongful. I learned I had a pending application on motion. I learned through this process when Colorado asked me for an updated letter of good standing, because in 2019 I had one, I immediately, the same day, sent an email, which is in the record, to Kansas requesting that letter of good character. I had no idea that my initial contact was in fact reportable and had not resolved in my favor. And so I learned that through that chain of emails, which is in the record. I hadn't had the opportunity because they immediately requested that from me, and I didn't know that Colorado and Kansas had been in communication. I had no idea I had a duty to report that, and only days had passed since I had been alerted that it was still an issue. However, I think that that is a matter that Colorado has jurisdiction over, not Kansas, and a finding of misconduct. And I say that because I've submitted that a final adjudication in another jurisdiction that a lawyer has been found guilty of misconduct would establish conclusively that misconduct for the purpose for Kansas. But conversely, I argue that Kansas 202, KRPC 202 note 5 notes that adjudication of misconduct is binding on Kansas. And until then, this matter is just premature. And even if it was not resumed, withdrawn, or admission was denied, this is not something that under any statutory authority granted to Kansas is automatically reportable to the Office of Attorney Discipline. Never in any case history has a jurisdiction sought discipline based upon a bar application that was withdrawn prior to a finding of misconduct. Similarly, never has a U.S. case history action been taken based on a denial of admission unless egregious circumstances exist, like those in Malone, and then an order from that controlling court was issued that their findings were reportable to other jurisdictions. Furthermore, the administrator seeks to impose its recent findings upon Colorado, which has never been done before in any known case history, to include her own cited cases. That's because the Kansas only has the authority to police the Kansas courts. Finally, I would differentiate this case from the misconduct that was not involving practice of law cases that she cites to, Crandall and Janowski, where this does not involve an otherwise public matter. Bar applications and their details are not for public privy in Colorado or in Kansas. And but for this administrator proceeding with this prong of the action over my multitudes of subject matter jurisdiction objections, the details of my Colorado application would have remained private. That's because policing its own courts, the public is protected in the applicable state when they accept, deny, or admit with conditions an applicant. Thus, no further action is necessary. And I would argue that then that prong of this administrator's case should be dismissed for lack of subject matter jurisdiction. May I proceed?
Yes.
I know I'm running out of time and I'm fearful about that. In due process violations, I stand by all of my prior motions as I do in the subject matter jurisdiction. The administrator and the panel were aware that their sole witness was acting in, that I alleged that the sole witness was acting in retaliatory fashion. And when they denied my mission, they misstated the rule and they suggested that I had more than the 30 days I had had time since January to subpoena records. And that's a misstatement of the rule. And I had only had 30 days. And after regularly requesting records, they denied my singular request for complete discovery. And so then I was not afforded the ability to fully confront nor review unredacted and total documents. Ms. Larkin herself had refused, even though I asked her for those records, even though she was aware her client had threatened me and refused to provide records in the past. She then, only 7 days before the hearing and after they had denied my motions, gently asked her client for records. And then when he re-forwarded the exact same documents and insisted that he had done everything he needed to, she let that matter lie. I know that I'm running out of time and I don't know if I have the time to address the violations, but I will stand on the idea that there is a culpable state that's written into violations related to 7.1A and 8.4 C and G, that it's very clear, but the legislation is requiring by the words that they chose more than just negligence or knowledge, as I have admitted to. That's because the ABA shows that this is not that administrative disciplinary actions are not intended to punish, but rather to police and protect the public. And that their experience has shown that when these matters can be cured and have been, that the public is typically protected. I'm all out of time. I haven't gotten the opportunity to argue my mitigating circumstances, and I'm wondering if I can be given grace to do that.
Yeah. Yes. I think we asked questions and Ms. Larkin ended up with more than her 15 minutes. I'd be So I'll just do it this way and ask you what your mitigating circumstances are that you would present to the court.
Okay. I would ask that reprimand and on the alternative probation or suspension stayed by probation be the outcome of this case. I'd like to ask the court to not take my arguing for exceptions as a refusal to accept responsibility. If I could go back in time, I would have disclosed, from what I understand now, I would have flushed out my temporary employment placement at the Boys and Girls Club and the related allegations the way I understood them, the way the police had communicated to me. Even though it was investigated fully by the police at least 5 times, James, the witness said, I still would have disclosed them and over disclosed like I did in Colorado. Sorry. I would argue, I don't know if I answered your question.
Could you give me some clarification? I think in earlier filings with this court, Ms. Morton, you suggested that you were winding up your practice and you're not going to practice anymore. Is that still what's occurring, or do you intend, or is it your desire to continue to practice law with a Kansas license?
I desperately want to practice. I'm really good at it. And I enjoy it. And so when my mental health compounded with COVID and my kids and all of these things became overwhelming for the sake of my clients, and I wound my practice down. My goal is not to practice the same way in Kansas because it requires me to appear in court more frequently. And I know that that's cost prohibitive, at least right now for me, but my maintaining this license impacts whether or not I can practice closer to home. And so my goal and my intention is to accept what the outcome will be for this and have the opportunity to move on. This is my life's work.
And you reside in Colorado still, is that correct?
Yes, Your Honor.
Okay, no, thank you.
I would ask that a reinstatement hearing and suggest that would be more of a punishment. In practice, supervision or suspension doesn't protect the public. My bar application, the allegations related to the Boys and Girls Club, the worst part of this, are 16 years in the past. All other issues have been resolved. I missed the 10-year cutoff by 9 years, by 9 months. It was 9 years and 3 months old. I had no reason to urgently apply to Kansas. My son didn't graduate from high school until the following fall, and I have no other ties to the state of Kansas. Had I known, and I was gainfully employed after being in law school in a non-legal way, I had every reason that if I needed to wait the extra months, I just made a mistake of dates like I did through all of my applications, and I'm responsible for that. And I know that.
May I ask a question?
Yes.
I want to understand that the reason that you didn't disclose the Boys and Girls Club, because it was within the 10 years, was because the question asked about employment and you believed it was temporary employment, and
Yes.
so it wouldn't qualify.
Right.
Okay.
And so I had more than one job with TSO PEO. So you'll see on there, I had multiple titles and multiple positions. My employer was the temp agency. My placement was at Boys and Girls Club, and I was placed in several other places by that agency. And so
did you put any of the other placements on the application?
No, and in fact, on my Colorado application where this was discovered, the question actually asked, was I ever terminated from employment? And I marked yes, and then explained, although I wasn't terminated from employment, this was a temp placement. I'm disclosing this to say what happened at my placement and my time during the Boys and Girls Club. And this was before I ever knew that whether or not I was a temp or a permanent person was an issue. And I don't know that I misunderstood the rule, but I know that I now would do it different. And also, I'm horrible. When I did all these applications, I was terrible with my dates. And I've owned that. I made a chart. I made so many mistakes about just trying to get generally based on my life events when I was employed, and I missed that mark just barely. So
And then for the Boys and Girls Club, were you prosecuted for that?
No, there was a full investigation, police report. In fact, one of the reporting officers was the Boys and Girls Club board member, and no probable cause was found. He, even up to 2021, was saying that he was asking for prosecution in the matter. I hired an attorney. My attorney told me that the matter was not going to be moved forward. And that was the last
so of course it wouldn't have come up under, you know, any kind of, have you ever been charged with a crime? Because you were never charged with the crime.
Never arrested, never arraigned, never brought, nothing.
Okay.
The only thing I had was the police contact, which on none of those applications asks that. But in Colorado, because I knew for sure then it was not 10 years old, I flushed that position out and said, and in fact, Ms. Larkin asked me on my 2019 Colorado application why I didn't remove that information, because it was 10 years old by then. And that was because I had already disclosed it in prior ones and it was auto-populated. I did make amendments to the section to say that my lawyer had told me that it was resolved, and it wasn't. And it was. I never was prosecuted after that fact. And I don't want to challenge more than I put in my brief, but Mr. Sullivan refused myself and Ms. Larkin to provide documents in support of showing I was employed before that time, that I importantly had knowledge that I had changed positions. He says there was no contracts, there was no conversation.
That's fine. I just wanted to know that. I appreciate your answer.
I would like to say to the court that my colleagues, who are often white and men, have been afforded probation and or short-term suspension for a definite period of time, as outlined in my opening brief, even where there were facts of theft from their clients, lying to law enforcement, criminal convictions, dishonesty, and etc. That was oftentimes by joint stipulation, that they were offered less than what I'm being positioned with, that the administrator is asking for here. Obviously, both the admission, the attorney admission to the bar and the oversight that we receive once we're admitted is meant to protect the public. I don't think that you can argue that the circumstances here related to my admissions are worse than the acts committed while someone is licensed. In fact, I would argue the opposite. I think this would represent a gross injustice and be disproportionate to the case precedent to even ask that I would be indefinitely suspended under the circumstances, given how far and remote all of the allegations are, and that I've never had a complaint by a client or any other employer before or after the Boys and Girls Club related to this, and that all other issues are resolved. I would just quickly tell you that my mitigating factors are that I don't have any prior disciplinary action. I've always cooperated with this process and been forthcoming and taken responsibility and made corrections. In fact, even my brief was said to be horrible. And after I read Ms. Larkin's beautifully written brief, although I had a sample brief, it was nothing like what hers was. And so I asked to rewrite the brief, which was denied, and I accepted, but I did submit a sample brief to show that I can receive feedback and apply it. I have provided a couple of character letters, and one of them's from my son, who worked in my office. And I've asked some of my opposing counsel if it didn't conflict with their position for letters, but I ran out of time. I also submitted a letter from my prior employer while I was in law school, which shows that I had more experience in courts and in briefing and assessing cases. But she also then spoke to her opinion of me, which was not requested as a character letter, but I submitted it just to show that. And she offered me the opportunity to work with her if that's possible. I've expressed remorse and embarrassment, and I still stay on that. I expect that it'll be really difficult, if not impossible, to get my Colorado license, and that's where all my family are. And that's where all my ties are. I do volunteer and I offer services to people who are oftentimes minorities and don't qualify for the public defender, but can't afford really expensive counsel. I give free advice to people who call me from Kansas where I can. I have an open scholarship available for, Kansas college students. I just have never gotten any applications about that, but I have donated books and materials and supplies during my time. Just two more things, I think. I've secured a practice mentor in the state of Colorado because my goal is to practice full-time there. And I submitted proof of that to the panel, or to the justices. I became part of, and I have an actual active membership with the Kansas City Defense Lawyers Association, and I have asked questions of them and sought help even in this matter and taken their feedback. I've retaken the MPRE and passed it since this has happened. And I largely took CLEs related to this and learned so very much more than I could have ever expected. And also that pokes holes in some of my prior arguments, so that I understood that I needed to back off of those, such as display of logos. Yeah, why that was important.
Mr. Steele, Justice Steele, did you have a question?
Yeah, I do have a question. I didn't want to interrupt your mitigating circumstances, but if I could try to understand a little bit better the technical aspects of the website question. And I pulled up your Exhibit B, which is the printout from the Weebly support page. And your website was on the publishing. I don't know what Weebly, the Weebly is a company that produces websites for people, I take it. Is that right? Yes. And then you have like a back-end management, content management site that you can log into.
Yes.
And the exhibit that you provided describes hiding pages from your splash page, or hiding pages from your navigation menu, excuse me. Is that right?
Yes, that was the information that they forwarded to me.
So were the pages that you have stated that you believed were not accessible to the public, do you know whether you used that function, that content management function, to hide those pages from the navigation menu?
No, and that's why I shut my website down, because that is the only information they could forward to me, was that if it's on the page, it could be discoverable. But I didn't hide these pages. They were on separate template pages that auto-populated like all the contact information template pages.
But my understanding is you're saying that you believed that those had not been published.
Right. And they didn't have any reference to that except for to say, refer to this spot, and if it's on the page, it can be discovered. If it's on the back end of the page. So no one has ever suggested that someone called me thinking I was Rob Davies. No one else.
From your understanding is that if you have you've got a draft website page that's not yet been published, that can somehow be accessed by a member of the public? That's what.
Yeah. And I had no idea. And there's literally a function at the top of the page when you're drafting them that you click and it's highlighted blue that says publish. Those were all.
Did you, was there evidence in the record? Like, did you testify that you did not publish the pages?
Always. And in my initial answer all the way through, I've always testified that I had no idea that unpublished pages could be accessed by the public. I still don't understand why that could happen, but I messed up and I used them, and I accept responsibility for that.
Okay, thank you. That's helpful to me. I appreciate that.
I currently do document review, and I've just been lately, which is what I was doing during COVID. And so I have oversight. There's multiple attorneys that oversee my work. And that's my sole source of income right now. And it's even limited by project. And so I don't even always have full-time hours. At the worst case, I would ask that I be able to do work where related to that, so that I can take care of myself and my kids. I think that reprimand is sufficient for this to haunt me for a long time, because I will forever have to disclose it, at least for many years to come. And I've cured all the things that I can. And I don't have anything further. Thank you.
Thank you. Any other questions? Ms. Larkin?
Thank you. I want to touch on a few things that Ms. Morton talked about. First off, Ms. Morton talked about Mr. Sullivan, the witness from the Boys and Girls Club. If you look at paragraph 17 of the amended final hearing report, the hearing panel made a credibility determination, and they found that Mr. Sullivan's testimony was credible and Mrs. Morton's testimony was not credible when it conflicted with Mr. Sullivan's testimony.
But is it true, Ms. Larkin, that no charges were ever filed against her?
If you look, I dispute what Ms. Morton said about 5 reports to the police. I saw 1 police report. I'm not certain where the 5 came from, and I've looked in the record in the last few minutes.
Well, I'm not talking about police reports. Was she charged with a crime?
She was not charged with the crime. The Boys and Girls Club, when they discovered the payroll fraud, they reported both things to the police. The police contacted Ms. Morton. She said, I have a lawyer. The lawyer said.
So this is from 10 years ago, and it was reported, and there's never been a crime charged.
That's correct.
It's 16 years ago.
Okay.
It was about.
And so this is something that you're saying that you would automatically say, even though a crime was never charged, that you would automatically say that she never could have come in.
Lawyers have to be trusted. And when someone has engaged in fraud and has stolen from a nonprofit,
there's been no, where are you saying she engaged in fraud? There's been no, this is you saying that.
It's not just me saying that, it's Mr. Sullivan and the records from the Boys and Girls Club.
Right, but the prosecutor didn't even believe there was enough to charge it.
I didn't call up the prosecutor. I didn't look into it.
Well, there's no documentation, right? There's no documentation to show that this was charged.
She was certainly not charged. I completely agree with that. She was not charged. Just because someone is not charged with the crime doesn't mean that the crime didn't occur. And I think that when we have someone who's trying to become a lawyer and be trusted with the money of others, we have to look very carefully at their trustworthiness. And engaging in fraud and dishonest conduct, as I believe has been established through clear and convincing evidence at the hearing in this case, that she basically took $400 when she went to Sam's Club and then overpaid herself $4,000 during the payroll fraud. That to me is sufficient evidence for me to base a request for a hearing and a request that her conduct be looked at closely. I don't think that we should admit folks who have stolen in the past. I don't.
Okay, and then on our bar application at the time that Ms. Morton applied, does it have an explanatory phrase of, what is the 8.1? What did she not disclose about her employment?
She failed to disclose her employment with the Boys and Girls Club.
She did, but she wasn't employed with the Boys and Girls Club. Would you agree with that?
No, I would not. She was employed by the Boys and Girls Club. In fact, if you look at her 2019 Colorado bar application, she discloses Boys and Girls Club as an employer. If you look at Mr. Sullivan's testimony, he talked about how she was initially hired through accountabilities. And then later in September of 2007, she became a regular full-time salaried employee, and she was in charge of their payroll. So she was in fact employed by them. The evidence, and this is one of the things that I think it's really important that you consider the hearing panel's ability to sit as far as credibility goes. They determined that Mr. Sullivan was to be believed on the conflicting testimony. And he
Was there
testified.
any evidence of like a W-2?
If you look at Exhibit 15, there are some paychecks.
Exhibit 15?
And also, if you look at Mr. Sullivan's testimony, he talks about how to kind of interpret those documents and where it establishes the hourly pay and where it establishes the salary pay, and how she paid herself twice. I think it was 3 pay periods, which amounted to about $4,000.
And was in the Kansas bar application, though, the temporary employer was disclosed?
In the Kansas bar application, yes, she put down, I'm not sure the difference between TSO and accountabilities, but accountabilities is the temporary agency that placed her at Boys and Girls Club. And she disclosed TSO as an employer, but she did not disclose the regular employment that she had through the Boys and Girls Club. Mr. Sullivan's testimony, I think, is going to be very key for the court in considering this, as well as the hearing panel's assessment in paragraph 17 of their final hearing report.
Would the temporary employer have knowledge of the alleged events about the overpayment and the cashing of the check? In other words, did that information give your office sufficient, information to reveal all of this through contacting the temporary employer?
I don't believe so. I don't believe that they would have had information about what Boys and Girls Club discovered after or at the time she was let go, just that she was no longer, because they were not employing her at the time of her termination. The Boys and Girls Club was employing her. So that relationship with regard to the Boys and Girls Club had already terminated. And then they discovered the fraud and payroll about 1.5 years later when they were doing an audit of their books and preparing that for the nonprofit paperwork. Additionally, Ms. Morton indicated that she didn't even imply that she had practiced motorcycle and wrongful death, but on her website for the July of 2021, she lists practice areas, and those were some of the practice areas that she included on her website. And that was certainly not in a hidden page, that was on the public page.
Can I ask you about that issue that I was trying to dive into earlier? What was the evidence about hidden versus not hidden, and how exactly that came about?
Well, the evidence would have been what Ms. Morton provided on direct examination from, actually, let me make sure. Ms. Morton did not testify on her own behalf. I questioned her beginning at page 43 of the transcript, and I haven't looked to see exactly what she testified there, but I do think that her position has been consistent since the inception of this complaint, and that is she was gathering information. She thought it was hidden. She didn't know it was searchable. It was discoverable. So I don't have any disagreement with her position about that. And the way it came about was the Roth Davies firm had I'm not sure what the right word is, but a company that reviewed that maintained their website and kind of evaluated their presence. And so they would run tests every month to see kind of what would pop up when their name was run. And when they discovered that, it was through a simple internet search of their law
Do you
firm.
know, or was there ever any evidence about whether or not these pages, and I'm looking at your exhibit 19, which is the print off, the July 30th print off of the website.
Correct.
Do you know whether or not the sub pages, I'll call them, where you have the URL has a backslash and it has backslash about, Do you know whether those were linked to from the front page of the website? And was there any evidence about that?
I'm not sure if Mr. Stratton testified about this or not, but that exhibit came to be by Mr. Stratton just searching the internet. So those would all be published pages.
And I looked through the transcript just now real quick, trying to find that. I didn't find anything about that. I guess what I'm wondering is, are there sufficient facts to support the panel's conclusion that this was dishonest conduct or fraud of some kind? Because, and I just can't tell. I mean, as at least I understand the way website publishing works, these were published, but respondents exhibit B from the Weebly help desk does explain that the Weebly owner has the ability to hide pages.
Certainly.
And the way Weebly defines that is they're still live pages, but they are not accessible from your front page. They're not in the navigation menu. In other words, if you don't have the specific URL, you can't get to the page. And I'm just wondering if that accurately describes these pages.
I think we have to kind of consider both the November 2020 website and the July 2021 website. And I think that the November 2020 website, whether it was hidden or not, it was discovered by an internet search. So whether Weebly has accurately described that to what actually happened, I don't know. But
Well,
I know,
understand that it was discovered because you have it and printed it out and so on. But just for the purpose of the question, if a person was trying to build a website and they clicked hide on all these pages after importing what they consider to be a template, which they're going to edit later, without realizing that these pages are searchable, I mean, is that enough to support the violation findings, if those are the facts?
yes and yes. I
But how? That when there's no intent to put this information in a public-facing format.
I think that we're charged with knowing what our actions have done. I think that it's a know or should have known type of issue. She should have known that it was available. She should have known that what she has done is available and has impacted the other law firm. I think that when she relied on this other thing, and I understand, I completely accept and believe that she did rely on them, but I also think that she's responsible for what she's put out there. July of 2021 is a whole separate matter. She intentionally put that out. That does not obviously have any Roth Davies information, but there was nothing hidden about any of the July, about Exhibit 19. That was all on her webpage.
And which exhibit is the November webpage?
It's embedded in exhibit number 1. And then if you look at Ms. Morton's response, which is exhibit 3, she kind of cuts and pastes and screenshots a variety of things. So exhibit 1 and 3, I think, are the basic places where that is at. This court obviously has jurisdiction over lawyers outside the practice of law. Ms. Morton argued that what she did on her Colorado bar applications is not subject to the jurisdiction of this court. That is simply not the case. I would rely on my brief regarding subject matter jurisdiction with regard to that. In Ms. Morton.
I'm sorry to interrupt you again and taking you back to the website question. Is Ms. Morton's characterization that, you know, from version 1 of the website to version 2, when it was reposted, that the items that were targeted and discussed with your office were removed, and what remained that later became the subject of the violations weren't really made known to her at the time the second version of the website was published? Do you understand the question I'm asking?
I do. I think what happened was it was brought to her attention that there were issues with her website. I do think that some of those issues were pointed out, but I don't think that we necessarily went through every single page and said, you need to fix this, you need to fix that. I think it's reasonable for the lawyer to know what is accurate, what's not accurate.
Well, I wanted to follow up on that also. Page 590, in the record. It's page 4 out of 6 in Exhibit 19. It's the page that referenced motorcycle accidents. Is it the disciplinary administrator's position that a brand new lawyer cannot advertise that he or she will take a motorcycle accident case?
I think that there's an implication that when you say practice areas and you list motorcycle accident, that's an area that you have experience practicing in. I think the implication is experience that just simply didn't exist.
Why? I guess I don't follow that. You pass the bar. I mean, that's what they tell us when we pass the bar. You're qualified to go practice law. Why can't you say, I'll do a sex crime, I'll do an auto accident, I'll do a wrongful death case, I'll do a motorcycle accident case? Why can't you say that?
I think you can say it, but I think the problem is the implication that she's got experience. Throughout her website, both November of 2020 and July 2021, she talked about an experienced attorney she is. And when she lists, where her practice areas and what she's, and you couple that with her allegation that she's an experienced attorney, I think it's reasonable to think, to conclude, looking at that website, that if you've had a motorcycle accident, you should go to her because she knows what she's doing. She's handled these in the past. I think the implication, the inference is there. I think it makes it misleading to the public.
Was this a 7 point, was that the 7.1 violation or the 8.4?
That was, it's dishonest conduct falls into the umbrella of 8.4C because that's the broad violation, but it's a specific violation in my mind of 7.1. One of the statements that Ms. Morton talked about during her argument was that she only days had passed when she was notified that the complaint still remained pending. And that's simply not the case. She was notified in January, February of 2021 that a complaint had been filed against her. She was never notified that the complaint had been dismissed. She had no information to believe that complaint had been resolved in any way. Certainly the investigation had occurred, but she had not received any notification whatsoever about the completion of that complaint. That complaint remained pending, and she should have disclosed that to the Colorado folks.
Okay, explain to me again how that works, that she violates the rules based on that she didn't disclose that a pending investigation. I mean, was there a question on there that said, are there any pending investigations against you?
There certainly is in Kansas, and I'd have to look through the Colorado one to verify that, but I know that they have an ongoing continuing obligation to disclose information.
You're not even sure what the Colorado, so you are tagging her with a violation, but you don't even know if the Colorado asked about it?
Let me take the time. Just a moment.
If I may, it's there. And I know that's not helpful to me, but it was just my misunderstanding whether or not I had to report it, if it was initial contact or like an initial police contact, or if there was an actual formal complaint. But in the Colorado bar applications, it did require me to update that.
Thank you for your candor.
And it was certainly an allegation that we made, and it was a conclusion that the hearing panel made as well. Thank you, Ms. Morton. I want to touch briefly on the continuance and the due process argument that Ms. Morton made with regard to the continuance. If she had taken any steps to domesticate the subpoenas, which she had obtained, I had no objection to her continuance, but she had taken no steps to domesticate those subpoenas. She also argued that our office violated her due process by withholding exculpatory evidence. Of course, certainly this is not a criminal case. Brady doesn't apply, but we didn't have any exculpatory evidence. We didn't have the information that we didn't provide to her. Mr. Sullivan provided every scrap of piece of paper that the Boys and Girls Club had, and I provided her every.
He did not provide her personnel file, did he?
He did. If you look at Exhibit 15, that's all that was in there. That is the beginning and the end. It has her application. It has her driver's license, her social security number. It has her, I don't know, in a variety of information. But Exhibit 15,
and it has her paychecks in there too.
that was added to after she was fired. It's, you know, kind of the personnel file as far as the termination of her employment as well. So it has the letters that he drafted to
I thought
document.
he refused to disclose something. I guess I must have read the record wrong.
She believes that he had some type of information about the payroll processing company. He, through the, I think it's exhibits I and J, which were not admitted, but are part of the record. I believe he identifies the payroll company. But he didn't have any more than what is in Exhibit 15. Exhibit 15 represents everything that he had, everything that he provided to me. And it wasn't something that I just provided her a few days before the hearing. I did provide her an additional copy a few days before the hearing that was more legible than what we had before. But if you look at the, in the investigative materials that she was provided, both in the initial investigation, as well as Mr. Stratton's supplementary one, we provided her that information at that time. So
Why
she
was there a need to do one that was more legible? Was the original one not legible?
If you look at Exhibit 15, there's some handwriting, and some of it, in a previous copy of it was harder to read, some of the handwriting than the copy that we ultimately used. I mean, I think you could read it, but it was more difficult.
If you don't mind, let me jump in real quick. What's our administrative status? I kind of remember somewhere between May and July that there was a question about having to pay the licensing fees, and I think the late fee we waived, but what's our status with that?
Ms. Morton paid her annual registration fee in the middle of August within the deadline set by Chief Justice Lukert.
Thank you.
Any other questions? Okay, thank you to both of you for your arguments today. The court will now take this matter under advisement and be in recess until tomorrow morning.